see here. House Lynch.
Yes, definitely.
Slavic. That's the order.
You ready for this? Hi, I'm Matt Hank.
Hi there, Nicole Slavic. Pleasure.
Nice to meet you.
Nice to meet you as well.
First, consider the budget.
So, home builders, farm bureau, and
Realtors.
realtors. Okay. Great.
If everyone could please grab a seat, we do need the members of Congress to return.
I work for one of the members.
Who's got a horse to take a posse out and get the rest of the members of Congress? Yeah.
They're on their way.
They're on their way.
Thank you. I just got some. Thanks.
If you give me an iced tea, if there's some lemonade, throw it in there. Please. Here's David.
Time to turn it off. You better silence your phone.
Here comes Lamar.
Here we go.
I saw David. Let's go.
See any time indicator?
I'll just bring it to order.
Might as well.
Let's bring this committee back to order.
We will now be commencing with the second panel of the hearing today. Full disclosure, what the EPA's water rule means for Arizona. The first witness to provide testimony is Ms. Smallhouse. Are you prepared to go forward? Thank you. You may read your statement.
Thank you very much. Thank you, Congressman Gosar and Congressman Schweikert and distinguished members of the committee for the invitation to comment on this very important issue. I'm speaking today on behalf of thousands of members of the Arizona Farm Bureau and serve as first vice president of the organization. My family has been farming and ranching the same land in the lower San Pedro River Valley for 130 years. We raise beef cattle, grow forage crops, mill mesquite lumber, and have a saguaro nursery. The newly proposed EPA rule for waters of the U.S. would be devastating to my family's farming operation, as well as hundreds of others in Arizona agriculture. The agriculture industry contributes over $12 billion to the Arizona economy and is heavily dependent upon the functions of an efficient canal system and the ability to carry out ordinary farming and ranching activities. The rule is ambiguous and will do very little to enhance our water quality or our environment in general. The definition of tributary has already been discussed today. Every dry desert wash, riverbed, or man-made canal which might have geographical connectivity, but very little flow connectivity to navigable waterways would be micromanaged by the EPA on our farm and ranch. There are dozens of ephemeral waterways and hundreds of dry drainages which crisscross the ranch, and at least half of our farmland exists within the 100-year floodplain of the San Pedro River. These dry desert washes might run twice a year in a good year for only a couple of hours and are no more navigable than a puddle here on the Capitol lawn. Yet, according to the proposed rule, would now be subject to EPA oversight before I could carry out ordinary farm and ranch activities, as is the same for all Arizona agricultural families. The agricultural exemptions included in the proposed rule are very disingenuous. The EPA has made claim that agricultural exemptions included in the rule are sufficient to keep Arizona's agriculture unaffected. This is simply not true. The exemptions are narrow, do not apply to many normal farming and ranching activities, only apply to farms and ranches in existence since 1977, and create a regulatory framework for conservation standards which were previously voluntary. It should be noted that these conservation practice standards of the NRCS are Cadillac standards and workable only under Farm Bill programs because there is cost share available to assist with their implementation. The exemptions are confusing, as in on my irrigation field, the ditch might be exempted if it's in the right year, but not the field. The proposed rule would essentially give the federal government and environmental litigants veto power over normal agricultural activities necessary to grow food. To farm and ranch is to be at the mercy of Mother Nature, not the whims of regulators at the EPA or the Army Corps of Engineers. When it's time to plant, it's time to plant. When it's time to move cattle, it's time to move cattle. We must be flexible depending upon the weather, and we cannot wait 3 weeks, a month, or even a year for a permit, which is not even guaranteed to us. It would likely be stacked with erroneous, inflexible, and illogical compliance criteria. The newly proposed rule would have us applying for multiple permits, multiple times a year, for ordinary land use activities, or face thousands of dollars in fines. Something that has not been discussed today is this also unnecessarily opens us up in our daily lives to EPA compliance with the Fish and Wildlife Coordination Act. So now in order to build a fence, not only would I need to get a permit from the Army Corps of Engineers, but I would also have to wait on a biological opinion from the Fish and Wildlife Service in order to be granted that permit. I have at least 10 critical habitat designations on my property. The ambiguous wording of the rule is ripe for litigation as left to the interpretation of agency enforcement and environmental litigants, which now could file citizen suits at their whim. The economic analysis is severely flawed. The proposed rule would have far-reaching negative economic impacts related to food costs, the vitality of rural communities, and dissolution of family farms. There is no way a family farm such as ours would be able to withstand the hefty fines which would be enforced as a result of this rule. I have no doubt that my family and hundreds of other Arizona farming families will be forced to break this rule on a daily basis, given that it is unavoidable to manage a farm or ranch without the ability to make critical decisions on the hour based upon the changing weather conditions. There's no possibility we could account for these costs in our operation. I would love to speak more specifically to the economic impacts, just to Arizona agriculture in general, but this would be very difficult to do considering the broad ambiguity and unknowns in the implementation of the rule itself. If there is a need for further regulation outside of the Clean Water Act or clarification, it should be at the local level within the state departments. The proposed rule is an example of federal agency overreach in regulating because they can and not because they should. How is the Lunt family, the Smallhouse family, the Knight family, the Haas family, or the Sharp family, and I could go on, how do we stand up to the EPA when the EPA has already bypassed the power of Congress and the power of the Supreme Court of the United States? All of those in agriculture take their use of water resources and water quality very seriously. I would like to be very clear. My kids drink from water from a well, which I have direct control over. I have just as much concern over their health as any Arizona mom for her kids, but this rule has nothing to do with clean water. My daughter Hannah is 10 and my son Johnny is 7. They live, work, and play on the land where 5 generations of family have lived and worked before them. In 130 years, we have overcome adversity in everything from the fight over territorial land, decades-long droughts, to extreme commodity price swings. We have done this through determination, hard work, and ingenuity. Now we face a new challenge for which I am determined to fight. But it pains me to think that after all those hard-fought battles, our own federal government wants us to fail and take away the rights and desires of my children to grow food. Thank you.
Thank you, Ms. Smallhouse, for that compelling testimony. I'm sure the panel will have several questions for you. Our next witness testifying is Mr. Robert Lynch. He's counsel for the Irrigation and Electrical Districts Association of Arizona. Thank you.
Good morning, Chairman Smith, Chairman Schweikert, Congressman Gosar, Senator Griffin. This is, I am counsel to the Irrigation and Electrical Districts Association of Arizona. Our 25 members and associate members serve electricity and water in both urban and rural environments to about half the population of the state and about 2/3 of the irrigated agriculture in Arizona. Primarily in the desert counties. I have a prepared statement which I forwarded to your staff. I noticed this morning there's a small typo in it, and I would, with your permission, ask that I be able to submit a substitute for that, and then ask that it be placed in the record. I'm not going to read it. I want to answer some questions for you that you haven't asked. First of all, as my statement says, they started saying they were going to give guidance, the two agencies, in 2001 after the Schweikert decision in January of 2001. This is not a guidance, it's a regulation. They admit in their preamble that none of the Supreme Court cases have said there's anything wrong with the regulatory definition they have now. But they're going to change it anyway. And the reason they're going to change it is they have figured out a way to play semantics with the significant nexus test that term was first used in the Swank decision. And then Justice Kennedy, as you know, and Rapanos Carabel expanded on it in the plurality decision in that case. And they say it's not a scientific term, so they come up with connectivity. Well, if you're going to go to a bunch of scientists and say, is a tributary connected to a water, the water course it feeds into, of course they're going to say that. If you go to a lawyer and say, well, is this law important to that law? What lawyer's going to say no? What doctor's going to say pills are not important? Medicines are not important. What they've done is collect up a study where they say all this stuff is important and it's connected and therefore it must be jurisdictional. They've put everything backward. Justice Kennedy's opinion was intended to draw a legal distinction, not a scientific one. It was intended to draw a line between what the federal government would regulate and what it would not. Now, Arizona can regulate everything. Groundwater, surface water, you name it. I helped write our law in 1975, and our definition of waters of the state is just everything you can think of, and several things you probably never did think of. But the point being, we would have a permit program so we get delegation, which we have, and if something else came up, we were all ready to attack the problem. Guess what? That was 1975. Nothing's come up. What we've got here in this proposal is a solution where there isn't a problem. Where's the crisis in Arizona over water quality? I can't find it. I don't think you can find it. Why do we need this? We don't need it. Are we taking care of business? Of course we're taking care of business. And one of the odd things about this proposed rule is they're dealing with two cases. There are two more last year in 2013 they haven't bothered to mention, in which environmental groups sued to try to enforce the Clean Water Act in situations that were the Supreme Court of the United States said, nope, that's wrong. The United States appeared, friend of the court, amicus curiae, in both cases supporting the narrower definition. So now we have 4 U.S. Supreme Court cases starting in 2001 trying to narrow the overreach of EPA and the Corps in administering this law, and they're turning all of that on its head in this proposed rule. To Congressman Schweikert's plant a tree example, if you have a wash on your property and it is a tributary, and guess what? Everything in Arizona is a tributary except the Wilcox Playa and a couple of other little potholes. And you plant the tree next to the wash, and you put the dirt from the hole next to the wash, where if it rained, which would be nice, some of it might get in the wash. You need a 404 permit. I know I'm dealing with one of those for a client right now. The event took place in 2007 in the spring. I got called in finally by their regular counsel in the fall of 2009. We're not done. It's a national permit. Jay Johnson he didn't know it might take a year to get. This was 2007. This is 2009. This is now 2014. This is a national after-the-fact permit for a 404. We're not done. Now, one of the problems, the guy handling it for the Corps is a retired Corps employee from New Mexico working on part-time contracts because they don't have the money and the staff to have somebody full-time working these issues here in Phoenix. How are they going to deal with all the rest of this? How are they going to go down to Cochise County every time they want to move cattle? What happens when our linemen have to drive a pickup across a wash? Because they've got to go check the power lines. They've got to check the transformers. They've got to put the radar guns up there to see if there's leakage. Work has to get done. And if we're dragging this out now, where are they going to get the people? How are they going to administer this overreach? They don't have enough people in either agency to do this work. And then they're going to tell us, but I'm sorry, you can't do your work until we've done ours? It's absolutely insane. And I will say, though, that at least the Science Advisory Board may have heard you. They're having a phone call on June 19th. In case you want to join in, you can tell them by the 16th and that you want to be on the call. And I found out that there is something at EPA called the Local Government Advisory Committee, and it has a Protecting America's Water work group. And they're starting to have meetings about this rule, and they had one in St. Paul on the 28th of May. And I found out about it by reading the Federal Register notice about it on the 29th of May. So they're scrambling, and I hope you keep up the pressure, because this isn't the only place where we're getting attacked on our water rights. The Forest Service is after us. The BLM is after us. You all, thank you, passed H.R. 3189 and the Water Rights Act that, if I remember correctly, you were a co-sponsor of, Congressman Gosar. They're now coming out with their own Clean Water Act guidance. Just spotted it in the Federal Register. The Forest Service is getting in the Clean Water Act business, and they're getting in the groundwater business. So this is just a piece of the puzzle, but it is a huge piece. And thank you for paying attention.
Thank you, sir. There'll be some follow-up questions for you. Our next witness is Nicole Slavic, representing the Arizona Association of Realtors.
Thank you, and good afternoon. Like stated, my name is Nicole Slavic. I'm the Vice President of Government Affairs for the Arizona Association of Realtors, and it's thank you for having me speak today. Appreciate it. I will keep my comments brief, as the National Association of Realtors submitted a letter to Representative Schuster on April 25th. The letter has been passed along to Congressman Schweikert's staff, and everyone else should have received a copy of it as to date. The National Association of Realtors strongly opposes the proposal as a thinly veiled attempt to expand the federal government's reach to almost any property with a wet area in the country. Though the EPA asserted their proposal is narrower than the existing regulations, these agencies unapologetically add new categories and catch-all definitions to those regulations, including all tributaries, all adjacent waters, and other waters, all of which are broadly defined. It is all but safe to say that regulators will claim that all new definitions and catch-alls will provide brighter lines for what is and what's out, and the benefit to property owners. What they are really saying is the draft rule would save bureaucrats time in denying more permits applications to property owners who are seeking to improve their very own property. The reality is the proposed rule will subject more activities to the Clean Water Act permitting requirements, NEPA analysis, mitigation requirements, and citizen suits challenging the application of new terms and provisions. On a statewide level, it is the fear that regulators will use any excuse to stop ranching activities on public as well as private lands. To that end, allowing the opportunity for people to challenge an unclear rule could potentially tie up a farmer or rancher who simply wants to modify a stock pond or waterway that they created in the first place. Also, anyone who may be on a waterway, and we have lots of them in Arizona, like the Verde River, would be subject to a 404 permitting expense and review to improve or rebuild an already existing structure that may not be on the water but is considered in a waterway. We have a lot of dry streams here, and without a clear rule, could unknowingly subject a property owner of permitting before they take action to improve their property. While we have not had a lot of experience in Arizona, there are Gulf states and wet states in the east and south where property owners literally lose their property because they had to fight the government on finding out that they needed permits to do minor changes to their own property. The potential adverse impacts on the economic activity have been largely dismissed by the agencies and are not reflected in the EPA's flawed economic analysis for the proposed rule. With that, I would thank you for holding today's roundtable, and I appreciate it.
Thank you, ma'am. Our next witness is speaking on behalf of the Home Builders Association of Central Arizona, Mr. Spencer Camps.
Thank you, and good afternoon. The association would like to thank you for holding this hearing and the opportunity for us to express our concerns over the new proposed rule offered by EPA and the Corps of Engineers. While the association, and just to let you know, the association is preparing detailed comments for the current deadline, which is July 21st. And while these agencies are promoting this proposal as merely a clarification that simplifies the process of determining jurisdiction, in fact, the proposal is quite broad and would return jurisdiction to where it was before the U.S. Supreme Court addressed it in both the Schweikert and Rapanos cases. The proposed rule, if adopted, will have a particularly harmful impact on Arizona and the slowly recovering home building industry that we represent. Because the proposed rule relies on a draft report that has significant substantive shortcomings, the proposed rule should be withdrawn until these shortcomings can be addressed. The scope of jurisdiction under the Clean Water Act, particularly over marginal aquatic features such as desert washes and arroyos or ephemeral streams in EPA parlance, is of vital concern to our members. Many of the HBACA members are home builders and real estate developers. In connection with developing and improving their land, HBACA members regularly construct streets, roads, install utility lines, related improvements, and grade and improve lots and other parcels of private land. In many cases, these activities cannot be conducted without impacting desert washes and other drainage features which are common throughout the Sonoran Desert and are found on many parcels of developable land, including land owned by our members. Due to broad agency approaches to jurisdiction, these features are often deemed to be navigable waters, subjecting these projects to expensive and time-consuming process of securing permits pursuant to Section 404 under the Clean Water Act. In addition, EPA regulates stormwater emanating from construction sites and discharge to the Clean Water Act navigable waters under the NIPDES program and associated state programs. And this same approach to jurisdiction makes it often impossible to construct a project in a manner that avoids these discharges. Compliance with stormwater permit requirements is likewise burdensome, expensive, and time-consuming. It is particularly troublesome to us that this program, designed by EPA on a national level, is primarily designed at limiting sediment charges to streams and rivers when virtually all of our construction sites, if they discharge at all, discharge to ephemeral systems, which naturally carry high sediment loads. In fact, these ephemeral channels can be damaged by discharge of low sediment water, which encourages channel erosion. The proposed rule represents a substantial expansion of jurisdiction. If adopted, it will have a significant adverse impact on the development industry in the form of increased regulation. The primary reason for this rule's approach to tributaries. Prior to the Schweikert and Rapanos decisions, the agencies routinely regulated desert washes as tributaries regardless of distance and amount of flow contributed to downstream traditional navigable waters. Schweikert and Rapanos stand for the proposition that a hydrological connection is not enough. There must be a significant nexus to a traditional navigable water for the Clean Water Act jurisdiction to apply to these features. Current guidance formulated in 2007 requires an analysis of individual washes to determine whether a significant nexus exists. This approach has led the Corps to disclaim jurisdiction on many smaller ephemeral washes due to the lack of a significant connection between such washes and traditional navigable waters. Yet the agencies are now proposing a blanket rule that would extend jurisdiction over all tributaries, regardless of the significance of the relationship of the specific tributary to the downstream navigable water. This will subject small desert washes that are remote from and have no significant nexus to a traditional navigable water under the Clean Water Act jurisdiction. If these smaller washes were properly recognized as non-jurisdictional, the regulatory burden of this program would diminish substantially. The basis for this expansion is the U.S. Environmental Protection Agency's draft science report entitled Connectivity of Streams and Wetlands to Downstream Waters, a review, a synthesis of the scientific evidence. This report is yet to be made final and was subject to a peer review process that criticized the report's binary approach to the relationship of headwater streams to downstream navigable waters. We have previously submitted comments on the report criticizing its tendency to treat all intermittent and ephemeral systems as a class, when in fact there are substantial differences in function and flow between intermittent and ephemeral streams, and more importantly within ephemeral system themselves. In short, while large ephemeral systems can have a significant nexus, small washes generally do not. The report fails to analyze this issue and therefore cannot support the agency assertion that all tributaries have a significant nexus. We believe that the proposed rule should be withdrawn until concerns with the report are addressed. We have other concerns with the proposed rule. For example, ditches and other man-made features can qualify as tributaries and hence be regulated. While there are exemptions for certain types of ditches, these exemptions are quite narrow, and we are concerned that as drafted, there will be a significant new regulation of man-made features, further adding to the regulatory burden. The proposed rule also includes a new approach to non-tributary waters and so-called adjacent waters. We have relatively little experience with the type of waters under consideration here and are concerned with how these provisions may be interpreted. The proposed rule also includes a significant expansion of interstate waters, a category of waters rarely relied upon by the agencies to assert jurisdiction in the past, to include all tributaries to such waters as a class. This too has the potential for a substantial expansion of jurisdiction. Finally, the proposed rule is silent on implementation and how existing permits and jurisdictional determinations will be affected. We believe that there will need to be a robust grandfathering provision that protects existing permits and determinations from having to go through a delineation process under the new rules. Moreover, many permits and jurisdictional determinations were issued for a period of 5 years and are under current practice routinely extended. Because of the substantial investments made on the basis of these approvals, the grandfathering provision should extend not only to existing approvals but also to extensions of those approvals. The proposed rule is not just a clarification. It represents a complete sea change in approach to jurisdiction in terms of tributaries from current guidance and introduces numerous new jurisdictional hooks that are likely to result in expanded Clean Water Act regulation. The HBACA supports sound environmental protection but believes this rule advances an overbroad approach to federal regulation. Due to the flaws in the report underlying the rule itself, the proposal should be withdrawn until the report's shortcomings are addressed. Thank you.
Thank you, Mr. Camps. Our next witness is Matthew Hink. He's an environmental manager with Cal Portland and has chaired an environmental committee for the National Stone and Sand and Gravel Association and is also testifying at the request of the Arizona Rock Products Association. Welcome.
Thank you. Chairman Smith and members of the committee, thank you for inviting me to testify on behalf of Arizona Rock Products Association at this hearing regarding EPA's proposed Waters of the United States rule. My name is Matthew Hink. I'm an environmental manager for Cal Portland Company. Additionally, I chair the National Stone, Sand, and Gravel Association Subcommittee on Water Issues and the Washington Aggregates and Concrete Association's Environmental Committee. Arizona Rock Products Association has been providing representation for over 41 member companies in the state of Arizona for 57 years. ARPA represents well over 6,000 employees at 584 facilities. Cal Portland Company produces construction aggregates, asphalt, ready-mix concrete, and Portland cement with facilities across the western United States and is a key player in the construction materials market. Cal Portland is proud to have been awarded EPA's Energy Star for sustained excellence for 10 consecutive years, from 2005 to 14. Aggregates are the chief ingredient in asphalt, pavement, and concrete, and are used in nearly all residential, commercial, and industrial building construction, and in most public works projects, including roads, highways, bridges, dams, and airports. Aggregates are a high-volume, low-cost product. Due to product transportation costs, proximity to market is critical. Generally, once aggregates are transported outside a 25-mile limit, the cost of the material rises exponentially. Over the past 8 years, the construction materials industry has experienced the most severe recession in its history. Since 2006, production has dropped 39% nationally and close to 60% locally. This expansion of the EPA and Corps' jurisdiction will have a severe impact on our industry. EPA claims this rule is needed because so many waters are unprotected, but that is not true. States and local governments have rules that effectively manage these resources. For example, states and many municipalities regulate any potential negative impacts of stormwater runoff and require detailed stormwater pollution prevention plans. These plans are required for every project, both during construction and continuously after an operation begins. The jurisdictional uncertainties in this rule are particularly problematic in the arid West. For example, the proposed rule fails to define the distinction between ephemeral tributaries and gullies or rills, which are exempt. The proposed rule also exempts vegetated swales, which differ from dry washes and other features of the arid West only in that they occur in more humid parts of the country and are therefore more likely to contain water. Similarly illogical is the proposed rule's definition of jurisdictional tributaries using the Corps' definition of the ordinary high water mark. That concept is excessively broad as applied to the arid Southwest, where the land is crisscrossed with lines or cuts on the ground caused by water flow during infrequent but high-intensity storms. The mere presence or physical signs of that water flows across desert lands from time to time is insufficient to establish Clean Water Act jurisdiction. Yet the proposed rule unjustifiably extends jurisdiction to these areas. Having a clear jurisdictional determination, JD, for each site is critical to the construction materials industry. These decisions impact the planning, financing, constructing, and operating costs of our aggregate facilities. JDs cost Cal Portland between $25,000 and $50,000 per site. If we have to move forward with the Corps 404 permit, our costs go up to as much as $500,000. Now, under the proposed revisions, many previously non-jurisdictional areas like ephemeral streams, dry washes, and other riparian areas could be considered jurisdictional. As a result, nearly any area we try to access will now be regulated and require additional permits. EPA should undertake a full evaluation of the effects of this rule will have on businesses. The proposed rule will put businesses at risk of fines up to $37,500 per day if a permit is required and not obtained. This could wipe out a business that did not realize a permit was needed for a work far from navigable waters. This is especially true in the arid West, where ephemeral streams and other waters can be considerable distances from traditionally navigable waters. We feel that EPA is required to comply with the Regulatory Flexibility Act and must seek input from small businesses before proposing a rule. EPA claims this rule is based on sound science, yet the Science Advisory Board, the group of independent scientists reviewing it, has not completed its review. The proposed rule has no clear line on what is in and what is out. It is so encompassing, however, that the EPA felt it necessary to specifically exempt residential swimming pools. Clearly, this is going to make it very difficult for our industry and other businesses to plan new projects and make hiring decisions. If we cannot clearly determine whether development of a site will take too long or cost too much in permitting or mitigation, we cannot move forward with that development. Taken further, a significant cut in construction materials production could lead to a shortage of construction aggregates, raising costs. NSSGA, our national association, estimates that material prices could escalate from 80 to 180% as supplies become limited. Given that infrastructure investment is essential to the economic recovery and growth, An unwarranted change in the way land use is regulated places needless additional burdens on the construction materials industry and would adversely impact aggregate supply and vitally important American jobs. ARPA and Cal Portland appreciate this opportunity to speak on the devastating effects of a broad expansion of the Clean Water Act jurisdiction on the aggregates industry. Thank you, Mr. Chairman.
Thank you. We will now turn the questioning over to Congressman Schweikert. You have 5 minutes, sir.
Thank you, and we'll keep a little clock close by. Bob, or Mr. Lynch, we want to play lawyer for a couple of minutes? Pull the mic close.
Are you going to try to play lawyer, or am I?
No, I'm going to let you play lawyer. And okay, Ms. Smallhouse is running cattle, and they're marching across one of their dry washes. Does she, if you were to take the new set of the rule and expand it as far as you can mentally, does she have an exposure?
Unless it's in the Wilcox Playa, which is a closed basin, unless they find connectivity there underground, that's the only place I can think of anywhere near the San Pedro that isn't jurisdictional. Yeah, they'd be altering. They'd be altering a water course.
Yeah.
By going across it. It's no different than a lineman driving his pickup across it because he's got to go check on a power line.
Okay. What if I had an aggregate mine over here in the dry salt riverbed, but it's dug fairly deep and it has some groundwater seepage in there? When we're all on the 101 or 202 freeway and we look down and we can see some water sitting down there. Well, would that water expose them also?
Yes, that's outside the scope of the Swank decision. That Swank decision was essentially a borrow pit for a waste disposal site, and they tried to use the migratory bird rule in their core regulations to claim jurisdiction under the Clean
But under
Water
this rule, that would expose them.
In this situation, they would find connectivity to that excavation with the subflow of the Salt River, and it would be jurisdictional.
Let's say I'm a new homeowner and I had a wonderful realtor sell me a house. It happens to be up in North Phoenix where I'm not only in a general floodplain, but I have this nice wash in the back. And the previous owner has gone along and put up a little retaining wall, put some trees up along that wash, but obviously moved soil, put fertilizers and other things. Do I retain, as the new homeowner, liability for something that the previous property owner did in touching that wash?
Yes. In a word, yes.
So I buy a property. I would have legacy liability for something that had happened before I was even the property owner.
That's true.
Let's say I am building a subdivision, or let's say I live in one. My homeowners association has a retainage basin that also has overflow into it. I can think of, I'm picturing ones along the Indian Bend Wash, but they're all over. And eventually that retention basin, will overflow into the wash, which flows towards the Salt River. Does my homeowners association now to be paying attention to those areas?
Yes.
And therefore the liability to every homeowner in that subdivision?
There is a scenario in which, in order to buy a home, in many places, especially in the desert parts of Phoenix metropolitan area, you would need an environmental attorney to examine the purchase before you made it. Much as people have to worry about cleanup costs under CERCLA or the leaking underground storage tank provisions of federal environmental law, buyer beware becomes much more frightening.
Mr. Lynch, you've been practicing in this area for how many years?
50.
God, you don't look that old.
I am that old.
Yeah. We were teasing earlier. I was a page here in the state senate in 1980, and he was around.
Had been quite a long time.
And the reason for this series of questions, and to our witnesses, to our audience, to our fellow panelists, is to try to understand this isn't sort of a theoretical discussion. There really is an exposure to every single one of you in this room in the way it's written, and to every one of us, to every piece of our lives, and it may be exposure you don't even know you have, but yet it's here. And with that, I yield back.
Thank you. We will now have Congressman Franks ask questions from the panel.
Mr. Lynch, since you've been around here for so long, I'll direct my first question to you, sir. In your view, did the EPA and the Corps conduct the regulatory analysis that is required by law in a manner that minimized the potential cost on small business? This is the bloomin' obvious question I'm asking you, if you could elaborate.
I searched the preamble for some explanation of how they analyzed cost in this, and I couldn't find it. And I think that's one of the major deficiencies of the process that they've undertaken. And they've made a mockery out of their denial of impact on small business. It's a travesty.
Let me follow up. I know I'm hitting this one point pretty hard, but I think this rule of law question is a big one. The Supreme Court has determined that the agency's interpretation of the Clean Water Act jurisdiction has gone too far, and Congress has failed to support legislation that would expand the Act's jurisdiction. Isn't this proposal, this rule, which will expand jurisdiction by executive fiat, a complete end run around Congress and the courts?
Yes.
Yeah, that's a good answer. All right. Mr. Hank, if I could turn my attention to you, you've raised very excellent concerns, I think, that about the vagueness or the vague terms and undefined concepts to the Clean Water Act regulation that this rule represents. Do you believe that, number one, that it's more likely that businesses will seek jurisdictional determinations for all of their potential activities, and how expensive are CWA consultants, and how long can the evaluation process take place? How long does it take it to happen?
Well, you'd be wise to seek jurisdictional determinations in any property you develop. The fines are $37,500 a day if you don't seek a permit where you need it. So you have to get a JD before proceeding. The determinations, we spend $25,000 to $50,000 for the determination, and if we have to proceed with the core permit, that's a big uncertainty for us. It can take years, so there's no defined time frame in which you can get a 404 permit, which affects our ability to plan for business.
Well, Ms. Malthouse, you did an excellent job, but I mean, if you could just reiterate how the washes and river dynamics on your ranch related to these activities. How are these washes related to navigable waterways from your perspective, and how does this affect you?
They're related in very little. I've actually, if I could call your attention to the photos over there, the posters. The top poster is the very bone-dry San Pedro River. The bottom poster is what is called Redfield Canyon, which is a major tributary or drainage on our ranch, which then goes into the San Pedro River. The San Pedro River, which would then flow into the Gila River, which would then flow into the Colorado. So the distance and the ability for water, when we actually get rain, we have to get at least, I would say, an inch of rain in a very short amount of time for any of that water to actually reach the Colorado River. Probably those pictures right there reflect areas that might run, maybe the bottom one, that wash might run for a couple of hours, one day a year if we're lucky. The San Pedro, a couple of days a year if we're lucky.
Yeah. Well, Mr. Chairman, I would just suggest the point I've been making here all day is that, number one, this proposed rule is an end run around Congress. It's an end run around the courts. It's a complete misreading of the existing law and legislation, and it has real effects on real people. And if it should become the norm, this process should become the norm, it literally threatens the very fabric of a republic. And so I would just hope that somehow that this concern that's exhibited so obviously by the people here that are here today would be an ongoing and growing process in America, because so much is at stake. And I yield back.
Well stated, Congressman. Mr. Smith, you have the floor.
Thank you. This panel has been very interesting. 4 of you all have testified about the impact on property, and then Mr. Lynch gave us the legal overview, so this was all very, very helpful. Let me direct my first question to Ms. Smallhouse, and it's pretty impressive that your family has been ranching for 130 years. That's 5 or 6 generations, I assume. But a tribute to you and to, shall we say, persistence in the face of sometimes adversity when it comes to droughts and everything else. You mentioned the problem of not necessarily being able to wait when you needed a permit. You can't always anticipate needs and so forth. But I also wanted to ask you about the problem that I think a lot of farmers and ranchers and individuals would face who are not necessarily going to read the 370 pages involved with this regulation, and that is you might not even know if you need a permit. You've already said the problem might be delayed if you needed a permit, but you may not even know if you need a permit, and then suddenly you find yourself subjected perhaps to paying fines of as much as $37,500 per day per infraction. To me, that's a major flaw in any kind of proposed regulation when people are not going to be aware of how it applies to them. Don't know if you want to add anything to that, but that to me is a major concern for a lot of individuals. And it also, I think, comments unfavorably on the government's constant overreach. And it seems to me that part of their motivation is nothing more than to control more of the lives of more of the people in the country. And that's also going the wrong direction. But do you have anything you want to add to the problems created by this proposed regulation?
Well, I envision, as I said, that pretty much every family farm, ranch in Arizona will be in violation of this rule at least one time during the year, and none of us can afford to pay $37,000 for that violation. We have some situations in Arizona where, because of the Clean Air Act, we have many farmers doing best management practices, like applying fertilizers through their water, that are trying to comply with the Clean Air Act, which will now be in violation of the Clean Water Act. So it pits, basically one compliance issue that you're trying to deal with against another. And I'm fairly sure that most of those farmers feel like they're doing the right thing and will be very surprised when they find out that they violated the Clean Water Act.
In violation of the regulation. Thank you. Mr. Lynch, not everybody here may know that your daughter Caroline, and this will be familiar to Trent Franks, who's on the Judiciary Committee, but your daughter Caroline is the Chief Counsel for the Crime Subcommittee in Congress, and we appreciate her great work over the years, and she has done a wonderful job. So Trent will back that up, I am sure, but thank you for being her father, shall we say. I'm sure all the good she does is directly attributable to your wonderful example and influence. Is that right? Not so.
This is going to cost me.
My question is this, though you mentioned the various court cases, particularly Supreme Court cases, that have rejected an expansion of the Clean Water Act. Why should the government get away with a proposed regulation that if promulgated by a lower court would be rejected by the Supreme Court? There's something wrong with that picture from a legal point of view. What's the justification, or why is it that the proposed regulation would be legal, whereas if it were a court saying the same thing, it would be struck down by the Supreme Court?
Well, there isn't any justification, Chairman Smith. The simple answer is that, and others have said it, is that they've tried to take a legal standard, significant nexus, first announced in Swank and then announced in Rapanos in the plurality opinion of Justice Kennedy, which is a legal standard, and turn it around and say, this isn't scientific, we have to be scientific. So we're going to talk about strength, we're going to talk about integrity, we're going to talk about connectivity. And then we're going to say that all tributaries and all adjacent waters, a new definition, not in any of the case law, are all per se jurisdictional. Well, I don't know how they do that when last year, twice, the Solicitor General of the United States, on behalf of the United States, appeared amicus curiae in 2 cases saying, no, the plaintiffs are wrong. This is not jurisdictional. This activity, one in Oregon on drainage from forest roads, and the other L.A. because poor old L.A. managed to concrete part of the L.A. River, and therefore they needed a permit. Supreme Court twice said no. The United States twice said no, that's not jurisdictional. Right. So now we've got 4 cases in the last 13 years which has said to EPA and the Corps, stop. And it's as if they just
and yet they're
throw
not
them in the trash.
And yet they're not stopping. Nothing seems to deter this administration from trying to impose more regulation of the American people. But I agree with you. Thank you for that. Ms. Laslavik and Mr. Camps, both of you all made the point that the impact of the proposed regulation is not just on rural areas, but on urban areas as well. Ms. Laslavik, you mentioned homeowners. Mr. Camps, you mentioned investment and developers. What is going to be the impact of the regulation, say, on home prices or on the willingness of individuals to invest? And on the way to your answer, let me also agree with and point out what was said a while ago by Mr. Congressman Schweikert, that everybody in this room is going to be impacted by this regulation. Sometimes we don't think of that, but David Schweikert made that excellent point. But Ms. Laslavik, do you want to answer? I think my time is coming to a close, so if you'll give very brief answers on to the impact of either private property prices or the investment and development of properties as well.
Certainly, Representative Smith, Chairman. I would anticipate that it would have a negative impact on the home prices moving forward. I believe that Spencer could probably speak to the price of development and what impact that would have on it. But from a perspective of a home buyer purchasing the property, whether it's through a developer or through a realtor where it's a property that's being resold, I would anticipate there would be a negative impact on the pricing, and there could be the potential for it to increase.
Okay. Anything to add as far as investments go or development?
Well, as it relates to our stormwater permits, those control measures cost anywhere from about $1,000 to $2,000 a lot, depending on the control measure employed. But the greater cost is the uncertainty on the 404 permitting side. Right now, we suffer from a lack of improved lots, and that is a permit you seek to develop and improve lots. And right now, that is a challenge in these economic times as lot prices or the cost of putting lots into production doesn't necessarily correlate to the end cost of the product, the home sale at the end of the day. So the time and money and effort put into the 404 permit process would be substantial, number one. But number two, as been mentioned, everybody's going to get one because you need to know whether you're in jurisdiction or not, and you're not going to take the risk of not having a permit.
Okay, thank you, Mr. Camps. Mr. Hink, my time is up, but let me just say you made a good point both in saying the impact of the regulation on both current businesses and future businesses. I thought was a good one, as well as the problem with interpretation of what it even means. So thank you for your testimony as well.
Thank you.
Yield back.
Thank you, Congressman Smith. Senator Griffin, you have 5 minutes.
Thank you. Just want to make a comment to Mr. Lynch. I got notified of that meeting on the 29th of May for the meeting on the 28th of May, so that was, I think probably we got notified at the same time. Ms. Smallhouse, I know the San Pedro River quite well, and there's no mention of where the San Pedro starts. It starts in Mexico. And I've been to the where it started, and I asked people that lived and worked along the San Pedro River about water in the river, and their comment is the same as what we hear on the American side. When it rains, we have some river water in the river, and when it doesn't rain, we don't have so much. So there is no regulation in Mexico as far as crossing the border and what we'll be looking at. The housing market for the realtors, the liability for the homeowners and the home builders, whether you're selling or buying, is something we haven't addressed, and our property disclosure statements will get longer because of that, and it is a definite concern. The American dream that we have eliminated almost in rural Arizona. It's tougher there than it is in metropolitan areas. Will be a challenge, definitely. And this isn't about clean water. It's about control of our lives. It'll affect everyone in this state, whether directly or indirectly. And the consequences really are not defined. It's our freedoms that are at stake, the ability to use our properties and our lands as we wish. We all want clean air and clean water. I haven't, as I go around the state in my district, I haven't met one person that wanted dirty water and dirty air. And the 90-day comment period is insulting. It's just a shame that we continue the battle, whether it be, and as I mentioned, our natural resource industries have made this country wealthy, and we live in the best country in this world, and yet we continually have battle with this administration and the rules and regulations that come down that affect every one of us. And so I don't have any additional questions for the panel, but I'd like to say thank you for inviting me to be a participant today. And thank you.
I'm not going to let Tom even intercede here because I'm taking my turn.
You may proceed.
Mr. Kamps and Ms. Leslavik. So the economy of the builders is vibrant and vivacious right now, is it?
No.
It's
No.
kind of what I thought.
Challenging.
It's kind of what I thought. So even new construction would be severely handicapped. I mean, in fact, people who have purchased property would look secondhand or secondly at whether I invest or develop that land. Would you agree?
I would agree.
So it'd have a significant application. I want to give you some statistics that I think will I'm glad most people are sitting down. The average cost of rules and regulations to a small or to a large employer is over $9,000. To a small employer is over $11,000. What we're going to see is a massive increase. What we're actually going to see is Obamacare on water. This is called the individual mandate. So all people will actually see this implications and the cost. So you're going to see this explode. That means all individuals will have their actual application. Mr. Lynch, you made a comment. It's about money? No, it's not. The agency has plenty of money. Their problem is prioritization. They don't work appropriately with local and state jurisdictions. You actually made that comment. And so from that standpoint, I would slightly disagree with you. Let me ask you a question. You were very articulate in regards to putting forward the Arizona Water Rights Bill. During that time, have you found any application in which water has been subjugated to less than standard quality or pristine quality in that application?
You mean in dealing with water rights application?
And outcomes in quality.
Well, as Senator Griffin said, I don't know anybody who wants dirty water. I mean, you can't farm with dirty water. You're growing things for people to eat, and you have. I mean, it's raw water as we call it, but it's got to be good water. And you don't want your children or your grandchildren, for that matter, drinking bad water. We're all very water conscious in this state, and I think we do a fantastic job. As I said earlier, there are no horror shows. Why do we need this here? What's going wrong in Arizona? Who's dying? Nobody. Things are working. And you know, and we can take care of these issues without all this help from inside the Beltway. But I don't know of any application with anybody I deal with in this whole state where there's a dirty water issue now.
Would you agree with me that what we're doing here with the expansion of the definition here is that we're trying to validate our jobs at the federal level within the agency of the EPA? You made earlier mention that we're looking for a problem that doesn't exist.
Yeah, I think EPA thinks it has found a very clever way to approach this whole issue on the basis of science rather than law, and to say this test, this significant nexus test, has to be based on science, and of course everything has a significant nexus in their view. So yeah, I mean, I don't know, maybe they're planning on building a second building.
Well, I'm going to come.
Southwest.
Are you familiar with this Andy Johnson case up in Wyoming? This is a gentleman that actually got his permits to build a pond through the Wyoming Department of Environmental Quality, and now is being fined $75,000 a day, not $35,000, $75,000 a day, and this is before the Clean Water Act. Are you aware of that case?
I'm not. No, I'm.
This is a gentleman that actually went through the state of Wyoming's jurisdiction of ADQ, or their equivalent of ADQ, getting permits to do such for a holding stock pond, and is now being threatened by the EPA to sue. So if you want jurisdiction about what's coming, here it is on the individual basis. Last but not least, you actually engaged in water and power, are you not?
Yes.
So how about that science on the about regional haze? How about that science up there in Navajo Generating Station? Their science actually defied their ruling. It actually complements that it had no significant implications in the regional haze on the Grand Canyon.
Well,
And yet we're still quoting science. That's what's frustrating. And to Ms. Ingalls,
I understand. The
to Ms.
problem is that the fix that was proposed wouldn't give you any kind of actual result you could see.
No.
It was beyond the scope of human eyesight.
and once again, that application for regional haze is primacy federal or primacy state?
Well, no, that's federal.
State.
Well, not in EPA's eyes.
Well, but that's my whole point is,
Yes.
coming back to Ms. Engel's comments, this is an issue that needs to be mandated back to Congress for jurisdiction and oversight. So I really want to thank everybody for their testimony today. Thank you. I'm done.
Yes, thank you, panel members, and that concludes the Q&A for the panel. We now will turn it over to public comment. Where's Penny Pugh? Penny, if you could go over to the podium. Anyone who would like to give a comment on the rule, what the members here would appreciate is if you propose or if you favor the proposed regulation or you're against it, and a brief explanation as to why. You'll have to give Penny your name, and there's 90 seconds per person to give their comment at this point, and she has a list already with some names on there, so please see her if you'd like your name added. We will start the public comment in just a minute or two. Do you have a list of names? Hold on one second, your mic is off.
Test it. Test it.
Rachel.
All right.
No, we're on.
Okay, test.
There you go. Now we can hear you.
I thought it was me. Okay, we'll start out. I have a list of 5 names so far. Andrew Walter, Andy Grosetta, Doyle Shamley, Michael Curtis, and Kelly Norton, and then we'll go from there.
Okay, Mr. Walter. Welcome.
Thank you. I think I'm a little too tall for the microphone. Can everybody hear me?
Yeah.
Okay. I don't know if this is appropriate.
Yes, please proceed.
Thank you. I'd like to thank the members of the committee for your leadership on this important issue that's incredibly important to the people of Arizona. Please know there's millions of hard-working Arizonans, middle-class families counting on you to shed light on this harmful proposal, which I disagree with. I have serious concerns about this proposal, the new EPA proposal coming out that we're discussing today. At its core, this controversial new rule will do 3 things: destabilize America's goal for energy independence, kill hundreds of thousands of jobs, if not more, and bust the budgets of struggling middle-class families. Unfortunately, this new federal power grab does little to advance public health, but does much to further consolidate power in an unelectable, unaccountable federal agency. Supporters of this controversial new EPA proposal claim the changes will produce jobs, cut electric bills, and save lives due to a cleaner environment. Unbiased observers will note many of these same people made conspicuous claims about the Affordable Care Act that proved false. Lessons learned, in my humble opinion. This controversial new proposal by the Obama administration completely disregards our democratic process, which must be held sacred by those in elected office. The President seeks to bypass Congress and, in so doing, the will of the people. This hyper-partisan style of governing is not constitutional or right. I'd like to suggest for the record that these new EPA proposals have very little to do with protecting the environment and have everything to do with consolidating power in Washington away from the free men and women who make this country great, just trying to provide for their families. And one final question I think is at the core of this debate: will this help or hurt struggling middle-class families at a time when our economy shrunk by 1% in the first quarter? And I think the answer is clear. This proposal will further hollow out the American middle class, the backbone of our economy, and I think that's unacceptable. I yield my time.
Here.
Thank you, sir. Penny, the next witness. Mr. Grosetta.
Andy Grosetta, President of the Cottonwood Ditch Association, and first of all, I want to read a letter addressed to the committee from our Ditch Association. First of all, thank you for conducting this joint field hearing in Phoenix. On behalf of the 325 shareholders of the Cottonwood Ditch Association, I am strongly opposed to EPA's and the Army Corps of Engineers' proposed definition in waters of the U.S. This newly proposed rule, if implemented, will adversely impact the landowners and our irrigation association. In addition, it will adversely impact farmers, ranchers, and other businesses in the Verde Valley. EPA's proposed definition and jurisdictional assertions could conceivably extend jurisdiction far beyond Congress's intent, as it was shared with your group this morning. If implemented, this new rule would be regulating areas that never have been jurisdictional under current regulations. Case in point, EPA proposes to include for regulatory purposes natural, man-made, or man-altered in the new definition of a tributary. The majority of all irrigation canals and ditches in Arizona and even throughout the West are man-made and were built during the late 1800s or the early 1900s. Our association, our canal, our ditch, namely the Cottonwood Ditch, was built December 10, 1877. Even some canals, such as the Central Arizona Project, who testified here earlier this morning, they would be classified as a man-made canal and can be under the jurisdiction of this new regulation. With the creation of irrigation associations and/or districts, millions of acres of wildlife and bird habitat corridors have been created in Arizona and other western states. We do not need the EPA or the Army Corps of Engineers to be throwing another blanket of regulations on private property owners who are producing our nation's food supply. Arizona's farmers and ranchers know the importance to protect and manage our precious water resources. We do not need the federal government's guidance and assistance to restrict our ability to provide the food and fiber of this great nation. We as landowners do not need to have increased regulations and possible fines up to $37,500 per day. In closing, given the significant flaws in this new proposed rule and supporting scientific analysis, the Cottonwood Ditch Association strongly urges the EPA to withdraw its current proposed rule. Thank you for your time, and thank you for hosting this field hearing in Arizona.
Thank you, Mr. Grosetta. Penny, the next witness.
We have Doyle Shamley, Apache County Natural Resource Director.
Again, Doyle Shamley from Apache County. Thank you, committee, for being here today and for having me speak. Most of the obvious flaws in this plan were brought out by the fine panelists today, so my comments will be very brief. There is obvious a total lack of jurisdiction on the part of the EPA to be able to do this mechanism. I would have to question not only their general jurisdiction, but they're exceeding anything in the Clean Water Act, and that is a definite fact. Now, when I look at people that different entities and elected bodies, from soil and water conservation districts to county commissioners and supervisors that range from Arizona all the way up to Montana, that I'm having to work this issue for them right now to write the substantive commentary to turn into the EPA. There are some other things that continually come up. Many people on the ground, these soil and water conservation directors, the people that manage and are the real stewards of our water of our western states, and these county supervisors and commissioners, what they urge is that Congress begin to push back on these agencies, as you have done on many fronts, but start considering these Fifth Amendment style takings, because when these agencies do a ruling that impact the ability of a person to perfect upon a property right, which water is, and the use of that water as a property right, it is a Fifth Amendment taking. And we need to start looking at this in a broader view, not just how bad the science is, because I almost feel that's a given. Dealing with natural resources from the agencies anymore, I thought I would see the worst of the worst on the last plan. I always told myself, nothing could be written more poorly. And then another plan comes out from an agency. Now, I hate to be so smart-alecky about it, but it's a fact. So please consider those Fifth Amendment takings. And I am glad you're here, because it seems as normal I don't see my congressional representative here for up in that region. But I can also tell you that on current projects right now on the ground, when I don't see the EPA out restoring the watersheds after the agency mismanaged fires, destroyed them, our county is. And I can tell you right now,